There we go. So good morning, everyone. I'm
Morning.
Elena Campbell, President of the Rochester Regional Chamber of Commerce. Welcome. Thank you for joining us this morning. As you know, we previously did, I think, a 6-week series, Brad. Did it end up being?
6 weeks.
Yep. With Brad Lambert from Lambert Law, who helped lead us through the executive orders of reopening businesses. We called it rebooting your business in safe mode. I'm going to go through, sorry, and mute everybody. We're getting some feedback here. Okay. And Brad led us through the executive orders as they were coming out with regards to businesses being allowed to reopen. So as we all know, last week, there was another executive order requiring the use of masks now. So I quickly reached out to Brad, asked him if he would be willing once again to jump on a call and lead us through this executive order. Then we also had information late last week that came from the county about a new grant program that is available for small businesses and specifically for those who've been hardest hit, the ones that were forced to close and businesses that still aren't allowed to reopen. So retailers, restaurants, theaters, music venues, salons, those types of businesses. And I reached out to our county commissioner, Adam Kokendorfer, and asked if he would graciously join us this morning to talk a little bit about that. I did get off the phone earlier, just about a half hour ago, actually, with the county, with the one-stop shop. And I have reached out to them and asked them if they could find someone or they would be willing to do a webinar for us specifically about this program. So they're working on that. And I also got a little bit of clarification on a couple of things, which I'll mention when we get to that part of the program. So welcome again, everyone. And without further ado, I'm going to turn it over to Brad to get started. And then I'll do a few announcements in the middle between the two sections of today. So Brad, help us understand Executive Order 2020-147, masks.
Okay, I'll do my level best. Can I share my screen now? Can you put on my share screen? It isn't letting me share, Elena. There we go. Am I on? Okay. All right. This is my presentation with regard to the mask requirements. And again, I want to thank everybody for having an interest in this, and we're grateful for your participation. As always, you can post any questions you like as we're going, and we'll be happy to address those when Elena is ready to put those back. And this presentation that you're seeing on the screen will be available on our website, our LinkedIn. I understand the Rochester Chamber has in the past also posted the PowerPoint presentation. So let's get right to the order here. Order was immediately in effect for individuals on July 10th, and of course, as you all know, took effect on Monday for businesses. The order itself, number 147, does cite some supportive studies showing that masks are helpful. I don't know that there are any definitive studies of that sort, but we all know the mask debate, and I'm not going to get into that. The thing I find interesting about this particular order, unlike many of her executive orders, it has no expiration date, which sort of defies the whole idea of an emergency and a temporary measure. But I'm sure if she was asked, she would say, well, I've been updating and amending and even dropping some of the orders as they go. So I imagine that's where that discussion would go if there ever was one.
Hey, Brad, 1 second. Can I have everyone make sure they mute themselves? And for some reason, I'm not able to mute people.
Okay.
There's one person. Okay, that's better. I think we've got everybody.
All
Thank
right,
you.
great. All right. And then the order applies to both individuals and businesses, as you've seen if you've taken a look at the order. And when the, I believe it was the Retail Association of Michigan, I may have the name wrong, when they contacted the governor's office, the governor said that the term businesses should be applied broadly. I believe people on the call and anybody who has a professional office, business office, an office of any type ought to consider themselves subject to, or location of any type. I shouldn't just limit it to offices. You should consider yourself subject to the order. Another interesting aspect of this order is it pretty much acknowledges that it is new because it does not supersede any other orders. So it is important to read this order in conjunction with other orders, which can be tricky at times, and we'll try to do our best as we walk through the elements of the order. The individual restrictions, I think you're all pretty familiar with these. In any indoor public space, an individual must wear a mask, which is interesting. Again, as an attorney, I look at the term indoor space, public space, excuse me, and I see that, there's a potential there for somebody to enter the space with a mask on, but then if you go into a space which is not considered public in the indoor arena, you could actually take the mask off. Now, I think that's an extremely dangerous position for anybody who's in the retail business, because most areas where the public will be in a retail business are going to be considered public spaces, particularly by the authorities. I think it's a little different for offices. If you have a private office and one person walks into your private office, I do not consider that a public space. To me, that's a more of a private space, and it's not being shared as a public space. So you could very well take the position that a mask would not be required in a space such as that. So it's very different for retail and for businesses and offices, in my opinion. The public transportation, I'm not going to get into that much. I don't think that affects all of us, but obviously if you're on public transportation, you need to wear a mask. The next slide, we get into the individual exemptions, and there are many. I'm not going to go into any in detail, but the one that probably is of most interest to this particular audience is the medical intolerance exemption, because that one's going to require some discretion. Essentially, I think the procedure you have to undertake is to ask the person, if they're coming with a mask, do they have a medical intolerance? And hopefully the person declares that they do. And really, you're just going to have to exercise your judgment, which it can be challenging. If the person says, hey, I have maskitis, okay, well, then you know that they're just putting you on, and they really don't have any problem with the mask wearing requirement. But if they can cite some specific medical condition, it cannot be attitudinal. It has to be medical. A lot of us don't like wearing masks. Most people don't. We're not accustomed to it. But if it's a medical condition that can be cited, to my mind, the business owner, the professional, can take that person's statement at heart and allow them to enter without a mask and not be in violation of the law. There are several exceptions, which I kind of call necessity exceptions. I classify them that way, such as if you're exercising, if you're eating, if you are, there's another one for the ID. You might have to pull your mask to have your ID taken. Those are obvious exceptions that still apply to this order. Then the other ones I think are pretty standard stuff that we all can understand. The religious service and giving a speech to an audience ones are interesting, but they're not really applicable here, so we won't get into them. The business restrictions. Now, these are restrictions in paragraph 3 of the order, which apply to what a business must do, and this is where it's new. So far, what we've dealt with is pretty much already been in there. It's kind of incremental for the individuals. The businesses, however, with some notable exceptions, such as salons and gyms, at least in Region 6, gyms didn't open down here, they had to actually enforce the rules. Now businesses have to. That's the big change here, is now it's incumbent upon businesses, again, the broad definition of businesses, to change the rules and to enforce the rules. Now, right away, my lawyer radar is going off when you say post a sign at the entrance, because I'm asking, okay, what's the entrance? And I believe it, my own interpretation, and I'm sure nobody at the state of Michigan Lansing offices would agree with me. My own interpretation is you do not have to post it on the exterior of your door if you're an office in particular. An entrance to me is more than just a exterior door. And if she meant for it to be posted on the exterior door, she could have said it. She could have said, look, you got to put, this has to be visible from the exterior of your office. She didn't say it. She obviously knows how to say that in orders because she's had that kind of specificity in orders before. So to my mind, again, for retail, I don't think you have much choice. For retail, you really don't have the kind of reception area that an office will have where you could have a more expansive definition of an entrance. I believe for retail and other like businesses such as restaurants, posting on the exterior of the door is pretty much going to be a necessity. Offices, I think you've got some room for maneuvering there as long as you're putting it in a place before the person can really enter the general area of the office. And it's important to notice, and of course the sign has to say you're legally obliged to wear a mask. It's important to note that the Michigan LEO agency might develop signs. So unfortunately, we're all going to have to kind of keep our eye out for that. If they develop signs and that agency says you must use these particular signs, then we're going to have to use them. That's a requirement that is in the order, so it is law as of this point, and you're going to have to take note of that. Now, it's important to notice that employees are not mentioned. Employee restrictions are not mentioned anywhere in the order, so the old orders, the existing orders, which apply to employees, still apply. They are not modified. The only modification is to customers and clients, not to employees. The 3 questions are not specified. So again, salons still have to ask the 3 questions, but businesses do not. And of course, again, pay attention to the indoor space, public space requirement, because you may be able to allow somebody, especially if you're in office again, to not wear a mask in specific places within the office that are not considered a quote unquote public space.
Brad, can you just clarify the 3 questions?
No, I can't, because
Which ones you're referencing?
Yeah, the 3 questions are it's funny because I say that because there are various forms of these 3 questions out there, but it's the employee screening questions that have been required for a while. And the employee screening questions are, of course, have you shown any of the symptoms? Have you been exposed to anybody? And have you traveled? And the one that's funny that I'm getting all kinds of different forms on is whether it's travel internationally, travel by airplane, or travel out of state. I'm getting on
Brad,
that question. I'm getting people across the board on that one.
So Brad, I'm glad you brought that up because for my business, my ice cream shop, I had my inspection through the Michigan Department of Agriculture.
Yep.
Yesterday morning.
Wow.
And it is not required now to ask if they've traveled outside of Michigan.
Okay.
It's internationally. So.
Yeah. And I still see certain sites that are requiring you to say out of state, but I agree with you that the international is the standard.
Right. And they told us, Michigan Department of Agriculture told us, they aren't enforcing any of the COVID stuff. They're not enforcement on this, but they did reiterate to me, we want to make sure, we want you to be following whatever the county is telling you.
Okay.
So I went on and downloaded the specific form from the county. It came in our PPE kits actually that they gave us. And it used to say international, and now it says only out of the state of, or it used to say both out of the state and internationally. Now it's only, have you traveled internationally? So I wanted to just interject there to make sure people knew what those 3 questions were.
Yes, because it is evolving. Thank you, Elena, for that clarification, because it's another one of these things that gets started and just doesn't stop, even when the authorities themselves stop it. And that's an important distinction for people to be making, because a lot of people this time of year in particular are traveling out of state. Now, here's the enforcement protocol as the order indicates for the authorities you'll have to be dealing with, such as the Department of Agriculture, even though they're not actually doing the enforcement. The language, again, the governor's office said the language in the order which says to protect workers, shoppers, and the general public, that language is intended to trigger as much enforcement by as many agencies as is possible. That's certainly the intent. So it can activate the state police, the local police, the attorney general, and many different agencies such as Leo and Laura. Those are state agencies. And of course, public health departments, which are listed there, to have enforcement powers with respect to this particular order. That's the intent, and that's the way the order works. The licensing agencies, this one is rather ominous. The licensing agencies are activated, so if a particular business that is licensed is not following these rules, they can actually be investigated for failing to do so. And of course, and this is the way that I understand, at least colloquially, that the state has been really enforcing this, the liquor license. Everybody knows how valuable a liquor license is. So, and a lot of businesses that do serve liquor are very much on alert with respect to keeping in compliance with this order for that very reason. That license could be at issue here if there's I would suspect that it would not be not be just a single incident, although that could happen, but more of a continuous systematic type of non-compliance by a business, which could put the liquor license in jeopardy. And I think what the governor is acknowledging here is there is a certain diversion between, or disparity, is the word I'm looking for, between the way local agencies have been enforcing her orders and state agencies have been enforcing orders. The state agencies are much more gung-ho about enforcing these, and I've even seen examples of it expanding. I think we had one of our calls we had a couple of weeks ago, somebody indicated that they had that there was a picture on the CDC website that was cited by the health authorities saying, well, gee, the picture says you have to do this, so gosh, I guess you have to do this. And that's just not the law. Pictures on the CDC site are not the law, but that's the kind of expansive enforcement you're going to get from certain agencies, and you got to be aware of that. And of course, the executive order does have the power of law. I know a lot of people do not believe that these orders are lawful or constitutional. Frankly, I find this mask order, in my own opinion, to not be constitutional. I cannot believe that you can make healthy people wear a mask. However, what I believe doesn't matter. What Justice Clement believes matters, because once it gets to the Supreme Court, she will be the swing vote. So until that kind of action takes place, this is the law of the land. This is the law. These are the rules we have to follow, and executive orders do have the force of law. So it's important to take note of that, regardless of how you may or may not feel about the enforceability or legality of this mask order. Now, the enforcement protocols for business is very simple. Thankfully, it is very simple. Your legal duty is do not serve a non-compliant objector. That's where your legal duty begins, and that's where it ends. That's all she has said in the particular order. And of course, she said other things, but in terms of what a business, a site has to do, this is what you have to do. And this can, of course, and this is why the retail group and several other groups have had real problems, because they're saying, enforcement is it could be a tough task, particularly when you have a non-compliant person entering the office or the retail establishment. Now, the governor's office has advised people to develop a compliance policy, and I think that's a good idea for some. Some of you will want to develop your own policy, but I'll tell you right now, it's not specifically required by the order. And even the courts who have ruled for the governor on her orders have stated it must be in the order. You can't just put a FAQ out there, an FAQ, or a guidance from on some phone call and expect that to be law. It's not. So your decision is whether, is it a good idea? Do I need to tell my employees in writing exactly what they should be doing? If it is, have a compliance policy. But be aware it's not specifically required by this particular order. In terms of enforcement, you obviously want to avoid physical force. I know probably nobody on this call wants to have to physically try to throw somebody out of their office or restaurant or store. And you're really well advised not to do that. I compare it to the landlord-tenant situation, which we're all much more familiar with. In the state law as it exists right now, if you're a landlord who has a non-compliant tenant, either for not paying rent or they're trashing the place, you, the landlord, cannot just run out and throw them out of there physically. That's called a breach of the peace, and you can actually be held legally liable for doing so, particularly under the landlord-tenant statute. I think the same principle applies here. You're certainly trying to enforce the law, but you can draw the line at any kind of physical contact or force whatsoever. Keep your distance, call the police if you feel the need to, if you feel threatened, but you do not have to, thankfully, you do not have to use physical force. Now, that, by the way, that concludes my review of Executive Order 147. Elena has asked me to touch upon a few other orders, so I'm going to go into that right now, unless Elena wants to take this in stages. You can signal me if you don't.
Yeah, why don't we have a few questions.
Okay.
Do you want to answer those first before we move on?
Yeah, let's do that.
Okay.
I like that.
Would a members-only facility be considered a public space?
Yes and no. A public space does not, for example, I'll take a country club. I mean, country club is a members-only facility, and they are subject to these rules. So to me, a public space, you know, you can't really draw a line. She's trying to draw lines, and she's acknowledged, the governor's acknowledged, it's very difficult to draw lines. But, you know, chances are, if you've got a space where you've got typically 5 or 6 people or more in the space, you got yourself a public space. I don't care what the setup is, and whether it's a membership or not. However, if it's 5 or 6 people in let's say 1,000 square foot room, well, you know, probably it's still a public space, but you've got less distancing requirements going on. So yes, a members only facility can be a public space, but is not necessarily one. And if the question is, does our membership status relieve us of being a public space? Well, the answer to that question is no. It can be a public space.
Okay. All right. Thank you. If you have a professional office and the public cannot access the private offices or hallways, does that require the staff to wear a mask? Social distancing is available.
No.
I think you answered.
Yeah, no, the employee requirements are still out there in orders 145, 76, and 36. I'm going to touch on 145 in a minute. So no, you still have to comply with those orders with respect to the mask requirement. If you can maintain 6 feet, if you have a private office that nobody enters, to my mind, clearly you do not have to wear a mask in your own private office if nobody else is in there and you don't regularly have a whole bunch of people running in there, in and out of there. So yeah, the private spaces stay private, and they, to my mind, are not public spaces.
Okay. And I wanted to share just a little bit. One of them, of course, is you are required to wear it outside if you cannot maintain 6 feet of distance. So as you know, we own an ice cream shop in downtown Lake Orion. It is all a walk-up window. It is all outside. We have no indoor seating. So what I did was I posted signs that said, you know, if you cannot maintain 6 feet of distance, we do ask you to please put on a mask. I did put the exceptions on there, that if you are a child 5 years or younger, or you are medically unable to tolerate a mask, that those were the exceptions. I also added to the sign, please be kind to our staff. They did not make this rule. So,
yes.
Just trying to remind people that we didn't make these rules. And what I have instructed my staff to do, I didn't write a compliance policy yet for my staff to follow, but what I told my staff, I said, if you're feeling uncomfortable with it getting crowded while people are standing in line waiting, you know, to be served, then I told them to call me, the owner. And I have high school students and young, college students working for me, and I don't feel it's incumbent upon them to ask anyone to put on a mask. I will come up and I will deal with it if I'm not there.
Yep.
So that's how we're proceeding to handle it at this point.
Yeah, and I believe a lot of the requirement there is what is an entrance. If that outdoor space that you're referring to, if that's not yours and they're not really entering your property with respect to that outdoor space, that would be a very interesting question as to whether you have any obligation to monitor the outdoor activity at all. Obviously, this order is, primarily meant for indoor spaces. But if you do have an outdoor space within your business, and there is a literal entrance to that outdoor space that's within your business, then yeah, your jurisdiction, if you will, to apply this order would indeed be in effect.
Well, and that was one of the things that we did consider, because we do have a large grassy area. We have 3 sidewalks that converge up to the walk-up window. And I thought, do I need to put a post up with a sign on it, at each sidewalk entrance to our outdoor space? So I put one right on the walk-up window where you place your order, and I put one on the side of the building where people move over. They move over about 10 feet to wait for their order. So I put a sign there as well. And we have the stickers on the sidewalk, where people should stand. They're actually probably 10 feet apart where they stand in line.
Yeah, and I would say sidewalks would clearly be, unless those sidewalks are specifically dedicated to you, and you could actually kick people off if they're not your customers. I would say that's not, you're not required, under this order at least, to enforce. The other areas, much would depend upon your level of control over those areas, especially for the exterior.
All right, thank you.
Mm-hmm.
I don't see any other questions on this section, so why don't we go ahead and move forward?
Okay. All right. There's 3 orders here, which I'm going to cover in a much more brief fashion. Executive Order 149 applies to food sellers, and I find it interesting that this one does have a termination date. It does rescind an earlier order. And essentially, the heart of this order is that these food sellers and pharmacies, and I've listed down here below who it applies to, have to give 2 hours a week exclusive service to vulnerable populations. Now, the order does not say it has to be consecutive. You can divide it up as you like. I obviously would do it in a way that's facilitative and not, restrictive. I would, 1 hour here, 1 hour there would probably be the best way to do it. 2 hours on a Tuesday would also be, I'm sure, perfectly acceptable under the order. And then, of course, there are a host of COVID-19 exposure reduction strategies listed in paragraph 2, and I've listed a few of them there, making sure there's access facilities, which could be a problem for some. If you haven't normally allowed customers to use bathroom facilities, that could present a problem. And the normal checkout employee restrictions and self-serve station restrictions that people are already pretty familiar with. And then you can see the rest of the requirements. And I will note that some of the food law compliance is relaxed. You'll have to read the order for that, but some of it is relaxed due to the exigencies of our current situation. Moving on to the next order that I would like to cover a little bit is to note that Order 145 was enacted pretty much simultaneously with 147, at least close in proximity, and it replaces prior Order 2020-114, which again, everybody's pretty familiar with. It's been in effect for a while. The familiar operating employee protocols are affirmed. She did actually, and I'm going to take a look at my copy of it, she did actually highlight where she has changed her previous order, and she indicates that she stepped up rules regarding meat and poultry processing plants where some of the outbreaks have occurred. She has omitted certain sections which were struck down by a Michigan court. And then she does have the languages that are common in the employee population. You have to do some communication and training in those areas. And of course, it's updating the order which came through 143 last week, partially shutting the bars and restaurants back down to the extent that they're primarily purveying alcohol. So those are the main changes. She's highlighted them herself, and I won't go into much more of that, other than to say that the 2020-36, the cautious objector order does remain in place under this order. And the last one I've been asked to touch on today was the emergency declaration that was just made yesterday. Now, one thing that interests me as an attorney is that she does declare that she's acting under the 1945 law. And anybody who's been following this is aware that the 1945 law does not have the 28-day limitation that the 1976 law does. So she's acting under that now specifically. And I did notice in looking at the law, the governor can issue reasonable orders. So her orders have to be reasonable. There is actually a legal requirement of that in the statute, which I'm surprised the court decisions haven't been alluding to more specifically. And there are effective area references that are made there. And to my knowledge, when she declares an emergency, one of the reasons for declaring emergency is it may impact eligibility for federal disaster assistance, but I will disclaim having a whole lot of expertise in that area. But these emergency declarations oftentimes are for that purpose, to qualify the state for those emergency relief packages. And that's the gist of the emergency declaration, which does expire as of August 10th. So that one does have an expiration date. And finally, these are the areas that Lambert Law practices in. We've supplied a little summary of our employment law and in real estate, business, and commercial practice areas, and then the others. And of course, we want to thank the Chamber for allowing us to have this opportunity to present these materials to you. We very much appreciate the opportunity. And with that, I'm done with my presentation, and certainly if there's any further questions, yeah, I'm happy to address them.
All right, thank you so much, Brad. We appreciate your willingness to jump in once again at the last minute. As those of you who have participated in our previous webinars with Brad, things usually change the night before.
Indeed.
And this was no different, actually. So we appreciate the time that you put into researching these things and helping us to clarify them. I want to share my screen now. And there we go. I just wanted to make a couple of announcements before we move on and introduce our county commissioner. We do have our first ribbon cutting coming up. Yeah, look at Maggie. She's like very excited. So tomorrow, Thursday, we have a ribbon cutting for Tribute Creek apartment homes, and this is one of the Mosheri developments. So we're excited to do that one actually in person. It'll be outside so we can social distance and make it safe. We have our virtual member orientation 101 coming up on Monday. We have the AM and the PM session. So if you want to know more about your member benefits, please take advantage of those. And then we have our 201 coming up. And in today's climate, where everything has been made virtual and we've all been pushed online, more important than ever that you understand the marketing benefits that you can gain through the chamber by using our member information center, the ways that you can post hot deals, events on our calendar, and news releases that we can then include in our weekly electronic newsletter, The Pulse. So Member Orientation 201 is where you can learn how to utilize all of that. And then last and certainly not least, our golf outing. We have rescheduled our golf outing. It was supposed to be the beginning of June. We've rescheduled it to August 17th. We're really excited about it. It is the only fundraiser that the Chamber does every year. So it's extremely important to the Chamber and for our organization. It'll be held at Great Oaks Country Club. So a private club. If you don't normally have a chance to golf there, this is your opportunity to do that. And we hope that you'll be able to come out and join us for that. And we really want to thank our presenting sponsor for this event, and that is Mosheri. We're very appreciative of their sponsorship so that we can hold this golf outing. And I believe Brad, Lambert Law, has jumped on as a sponsor as well. So we appreciate that very much. So with that, I am going to flip over to, I've got it open here somewhere, right here. So there's a new program that's available through Oakland County to help small businesses. It's called the Oakland Together Small Business Recovery Grant. And I want to thank Adam Kokendorfer again, who is on vacation and has graciously agreed to join us today to talk about this new opportunity to help small businesses. So take it away, Adam.
No, I appreciate it, Elena. Thanks a ton to you and to the entire chamber. I wanted to jump on this and just talk briefly, just because I know these grants have been coming to people fast and furious at a very quick pace. And this one time sensitive, it's competitive, which means there will probably be more applications than we have money available. And so I wanted to get this out and push it out to people as quickly as possible. As I mentioned, there have been a lot of grants, some just generally to small businesses, some to nonprofits, some to cities, some to just individuals have a hard time making rent, for example. This one is targeted at a very specific group of small businesses. They're the ones, some of them have been probably hit the hardest by some of this. And the categories are this. It's retail, which I imagine are a decent number of people who are part of the chamber and maybe on this call. Food and lodging, personal services, business services, entertainment and recreation, and construction and maintenance services. And if you want to take part of this grant, you've got to have fewer than 100 employees, which I imagine a lot of our chamber members. You've got to have a location in Oakland County, and you had to have been affected by COVID. There had to have been a loss of receipts or sales. You've got to be operating maybe at a reduced level of production, sales, or employment, or you had to have maybe temporarily closed some of your operations. The grants are going to be anywhere between $2,500 and $10,000. You've got between now and August 24th to apply. If you have any interest, I'd encourage you to apply sooner rather than later, because these applications are going to be reviewed throughout this application process. So get them in early. And this is all coming from the federal money that we received through the CARES Act. And so that's, again, why it's time sensitive, right? Number one, we want to make sure that we get these out to the people who need it as quickly as possible. And also, the federal government has a deadline on us. I mean, we need to spend all of this, if we're going to spend it, between now and December. And so I'd encourage you to go out, take a look. Go to oakgov.com and click under the COVID and the grants tab, and the application will be right there. You can apply today if you'd like. And happy to answer any questions that you may have. This has been a bipartisan effort, Republicans, Democrats alike, everybody trying to help out our small businesses as quickly and as responsibly as we can.
Thank you so much. And I'm putting the, I put the link in the chat box for anyone who wants to look at it. And I wanted to let you know, I'm going to share my screen real quick and I'll show you. So this is the Oakland Together Small Business Recovery Grant. And one thing I just want to note, I'm going to hit the back button here quick and I'll show you. It's a little bit confusing, and I did notify the county about this and they're trying to get it corrected. There are, oh, they fixed it. They did fix it. They had a different name on this page And then when you clicked on it, then it said Oakland Together Small Business Recovery Grant. So it was very confusing because they had two different names. And so people were thinking there were two different programs.
Yeah.
So the other one that I want to mention as well is this one, which is the Michigan Small Business Restart Program Grant. That is another new program that's available, money from the MEDC. So while the money that Adam was talking about is coming from the CARES Act, this money is coming from the Michigan Economic Development Corporation down through our EDOs, our economic development offices, which Oakland County is one. So this is a different program. So there are two different programs that are now available, and I wanted to make sure that people knew that. And this is the link. I put that link where you can find both of these in the chat box.
No, that's great, Elaine. I'm glad you made both of those points because there are a lot of grants out here, and that's one of the reasons why I want to be there. And it can get confusing. And another requirement that I wanted to mention with respect to the first grant, the Small Business Recovery Grant that I mentioned, is that if you are a business owner and you're in an office space, for example, if you own your own building, or if your business is operated out of your home, one of the requirements is you have to be current in all of your property taxes from 2019 or before that. So that's just an FYI before you apply.
Okay, thank you for that. Thank you. We are working on, as well as I mentioned earlier, we have contacted the Oakland County One Stop Shop, and I see that I just missed a call from them while I was on here, but we've contacted them about doing a webinar specifically about this grant and this grant application process. We've also contacted the MEDC about having someone do a webinar on that program as well. That site is actually down right now. They took it down at 11 a.m. And then we were also informed that the Oakland County, Oakland Together site was not working as well. So they're having a little bit of difficulty with that one too. But as of an hour ago, I know they were working on fixing it. So we do have to have a little bit of patience with these things as well. So we're working on getting you webinars on both of those. So, keep an eye on your inbox. We will send information as soon as we have it available on those. We're also working on, I have a meeting tomorrow with two people from the SBA. We're working with them on doing a webinar on the application process for having your PPP and your SBA EIDL loans forgiven. So look for that as well. We're working on a webinar to address that too. So trying really hard to get all the information we can into your hands as quickly as possible to help everyone navigate these difficult times. So Adam, is there anything else that you'd like to add?
That's it for now. Just appreciate everybody listening. If you do have any questions, obviously you know where Elena's at. Elena has my contact info and she has the county as well. So there are a lot of different parties. I'm not on the oversight committee, but we can certainly get in touch with those people quickly and answer any questions you may have.
Thank you. And there is a question, and I'm actually trying to get clarification on this one. And you may not know, Adam, and that's okay. If you were approved or denied for a previous Oakland County grant, can you apply for this one?
It's a great question. I don't know that, but we can get you the answer very quickly, I'm sure.
So yeah, I was very confused because when I looked yesterday at the website, at the information, it specifically said that if you had previously received one of the Oakland County Small Business Stabilization Grants, you were not eligible for this. Now, when I was on the phone earlier today with the One Stop Shop, I was trying to find that again, and it's gone now. I believe they have taken that requirement off. But the One Stop Shop, again, is trying to get the answer for us about that, because I specifically saw it yesterday that you weren't eligible for this, but now we cannot find that language on the website. However, we discovered that some other things with regards to this grant had changed on the website too. So I think, like a lot of things, as they roll these things out, changes are happening rather quickly.
No, it absolutely is. In fact, I think they've learned some lessons from the previous grants, and that's where you're seeing some of these requirements pop up. So the county executive's office is administering this, but we can get those answers quickly.
Yes. Well, and thank you so much, Adam. We appreciate all the work that you do. As you know, one of our county commissioners, you've always done a great job of informing us about what's going on. I received an email from Adam as soon as this program became available, notifying us about it, wanting to make sure that our businesses knew about it. And we really appreciate everything that you do.
No, I appreciate that. Thank you very much, and the opportunity last minute to come on. Thank you.
Yes, yes. And Brad.
May I ask a question? Yeah. I want to ask a question, Adam, on this, if I may. Does this program, and thank you for presenting this, by the way, much appreciated. Does this program have the typical provisions where it could transfer from a grant to a repayable loan based upon qualification, even post application?
I believe this is just a straight up grant, which is it's call a forgivable loan when you're, but it's not a loan. How's that? It's essentially free money.
No, I appreciate that. I just wonder if, a lot of times they say, okay, if you don't do A, B, and C, we're going to convert it to a loan.
Yeah. Yeah, I think they did that in some of the ones first time around and then changed that just because it's difficult to administer. And I think the county has its own reporting requirements to the federal government.
Okay. Thank you.
Right. And Brad, any last minute thoughts or anything you want to share?
No, I'm fine. But thanks again for everybody for listening and attending. Much appreciated.
Okay, we don't have any more questions in the chat box, but does anybody have anything else before we lose our two experts here? No? Okay. Well, thank you everyone for joining us today. We really appreciate it. Watch your inbox. We are furiously working on bringing you some more webinars to help clarify these new programs and lead you through all of this. As I've said, I think on every call, we're all experiencing some difficult times, but together we're going to get through it. Okay? Have a great day.
Absolutely. Thank you very much.
Bye, everybody.
Thanks, Elena. Bye-bye.